I call this hearing to order nearly a quarter century after the Good Friday Agreement ended the Northern Ireland conflict, and also as we arrive at an inflection point where the consensus behind the agreement is threatening to fray. As many of you know, I have previously chaired some 17 congressional hearings on human rights and the peace process in the north of Ireland. I have also authored a law to prohibit members of the RUC involved in certain gross human rights crimes, such as the death of Patrick Finucane, from training at the FBI Center in Quantico, Virginia. That legislation and other resolutions I've authored that passed the House put the United States government on record that we reject human rights abuses and call on all parties in Northern Ireland, including those in government agencies, to adhere to international human rights standards, transparency, and establish an independent judicial inquiry into the murder of Patrick Finucane and others killed during the Troubles. Among those resolutions was a resolution I introduced in 1998 that passed in the House, H-Con Res 152, called on all parties, remember this is 1998, in Northern Ireland to integrate international human rights standards into the peace process. Next year, in 1999, H-Res 128, that condemned the murder of Northern Ireland human rights attorney Rosemary Nelson, who also appeared at one of our hearings. Then it was H-Res 740. And I'll never forget Rosemary when she was being threatened with death by the RUC, and she was killed. She was assassinated. A wonderful, wonderful attorney. Then there was H-Res 740 in 2006 that called on the UK to establish an independent judicial inquiry into the murder of Patrick Finucane. Then in 2007, H-Con Res 20 again called on the UK to establish an independent judicial inquiry into the murder of Patrick Finucane, as recommended by the judge in the case. Let me just say that the proposal by the United Kingdom Secretary of State for Northern Ireland, Brandon Lewis, to enact a new statute of limitations will grant immunity to those responsible for the estimated 3,500 killings over the course of 3 decades to that conflict. That ended with the agreement in 1998, and it imperils, in my opinion, and I think many others, the fragile peace process in Northern Ireland. Moreover, the new proposal facially violates the devolution agreement in 1998, in effect, home rule by Northern Ireland, as well as the 2014 Stormont House agreement that provided for an historical investigation unit to enable justice for the victims of these crimes. All parties in the Good Friday Accord across the sectarian divide had agreed upon the profound need for justice and accountability for those crimes, and their victims need to be, there's no peace when there is no investigation and absolutely no closure. It was a significant accomplishment given the legendary chasm that had divided across the centuries. Yet instead of justice, they are now confronted with impunity, masquerading as immunity. The Good Friday Agreement has worked and will only work because of the parties have enough confidence that those other parties to the agreement will abide by its terms. Yet now, one party to the Good Friday Agreement, the United Kingdom, is contemplating a unilateral decision to declare immunity by passing a law, a statute of limitations for the Trouble-era killings before there's been a full accountability against the express wishes of nearly every major actor in Northern Ireland, be they Catholic or Protestant. This seriously erodes the confidence of the remaining parties to that agreement as to the UK's commitment to the pact, and thus undermines the peace achieved by the Good Friday Agreement. The UK is a close ally, no doubt about it, and a strong partner in the promotion of human rights and democracy across the globe, alongside with the United States. But this unilateral proposal is profoundly unjust and cavalier, taking the peace in Northern Ireland for granted. In this, Britain stands alone. Not only have all major political parties of both the Republic and the North condemned it, Republican actors such as Sinn Féin on the one hand and the Democratic Unionist Party on the other, but also UN experts, such as the UN Special Rapporteur on the promotion of truth, justice, and reparation, Mr. Fabian Salvioli, and the UN Special Rapporteur on Extrajudicial Summary or Arbitrary Execution, Mr. Maurice Tidball Binns. They both called on the UK, to, quote, refrain from regressing on their international human rights obligations through the establishment of a statute of limitations for conflict-related prosecutions and barring all related investigations, inquests, and civil claims, close quote. This matters so deeply to the people of Northern Ireland because the pain of loss that the loved ones who remain feel every day will never go away. This proposed statute of limitations hurts them the most, and it means that they will never have closure, and the killers who are responsible for those acts will never be held accountable, deepening the wounds that now will never close. Some of our witnesses today lost family members during the Troubles. In 1989, paramilitaries from the Ulster Defense Association, working in collusion with the British authorities, killed Geraldine Finucane's husband, Patrick, and wounded her. I would just say, parenthetically, Geraldine has testified before. Back in 1997, she notes this in her testimony, I chaired a hearing, and Michael testified and did a brilliant job defending against this impunity that we now seeing reemerging. In 1990, British soldiers shot Mark Thompson's unarmed brother Peter, along with two others. In 1993, Irish Republican Army bombers killed Alan Mcbride's wife, Sharon, and her father, Desmond Frizzle, in their fish shop in Belfast. That bombing killed 7 other people, including elderly and small children, and injured nearly 60 more. As we all know, the list goes on further, as these are only a handful of the terrible acts from the 3 decades of the Troubles. The fact that there is not one person who lived through the Troubles who hasn't been impacted in some way by that violence. The crimes by themselves cry out for justice, but those cries for justice are greatly amplified when considered in light of the broader need for accountability as the key element in maintaining the peace, one on Good Friday. Finally, I want to share with you that I intend to submit a resolution that states that we stand in solidarity with the victims of Northern Ireland conflict, calls upon all parties to adhere to the terms of the Good Friday Agreement, and calls upon the United Kingdom to walk back this proposed statute of limitations. With that, I look forward to hearing the testimony of our very distinguished witnesses, and I would like to yield to Co-Chair McGovern for any comments that he might have at this point.
Well, thank you very much, and good afternoon. And I join Co-Chair Smith in welcoming everyone to today's Tom Lantos Human Rights Commission hearing on accountability for the human rights violations committed in Northern Ireland during the Troubles. I especially want to thank our witnesses for joining us today. I deeply appreciate their commitment and their decades of work on behalf of the rights of the victims and survivors of those violations. You know, I proudly hail from Massachusetts, and Massachusetts members of Congress have long been leaders in support of peace, human rights, truth, and justice for Northern Ireland. From House Speaker Tip O'Neill to Senator Ted Kennedy, to the current dean of our delegation, Congressman Richie Neal, who has led the Friends of Ireland caucus for many years, I'm proud that today's hearing continues that history of support for human rights and accountability. Between 1969 and 1999, 3,500 people died in political violence in Northern Ireland. More than half, 1,800, were civilians. The need to acknowledge and address the suffering of the victims of violence was recognized in the 1998 Good Friday Agreement and brought the conflict to an end. This need has been reflected in many efforts over the years, including the establishment of the Commission for Victims and Survivors in 2008 and the ongoing investigations conducted by the Police Service and the Police Ombudsman for Northern Ireland. The commitments in the 2014 Stormont House Agreement to create a new historical investigation unit and an independent commission for information retrieval was widely welcomed and seen as an important step forward. But 50 years after Bloody Sunday, there just hasn't been enough progress. But that is not a reason to stop trying, or worse, to reverse course. Yet that seems to be what Prime Minister Boris Johnson's government proposes to do. Although the government pledged early on to finally create the legacy bodies agreed to in Stormont, it later changed course. It now proposes to end all troubles-related investigations and prosecutions in the name of efficiency and reconciliation. The proposals include a statute of limitations and an amnesty that, as we will hear today, is far more sweeping than the one enacted by Chilean dictator Augusto Pinochet in 1978. Look, it is hard to come to terms with the past. We know this from our own experience here in the United States. We are still dealing with the legacy of slavery, a crime against humanity 150 years after it ended. But however painful it is, acknowledging the past and dealing with it is necessary. It is legally necessary because victims have rights. The right to know the truth about what happened and why, the right to justice, meaning the right to investigations and prosecutions, and the right to reparations, to try to restore some of what was lost during a conflict. States are obligated to do their best to fulfill these rights, even more so when they are directly involved in or responsible for the abuses. It is practically necessary because without accountability, a society never achieves reconciliation. We have seen time and again how the absence of a reckoning with the past reinforces and deepens social divisions. Processes of accountability restore victims' dignity and provide redress, and that is what makes reconciliation possible. And finally, dealing with the past is also morally necessary. It is simply the right thing to do. You know, we're living in a moment when human rights are under serious attack. We easily recognize the attacks when they come from authoritarian regimes, a China, a Russia, a Saudi Arabia. But human rights are also being undermined from within formerly democratic states. I believe that the proposals we will hear about today are an example of that. The fact that the proposals have generated such overwhelming opposition throughout the UK gives me hope, and it gives the government a good excuse to step back in order to avoid a mistake, a major mistake. Now is not the time to give up on accountability for the terrible human rights abuses committed during the Troubles. Instead, it is time to redouble efforts to reveal the full truth about what happened and hold those responsible accountable in order to preserve the hard-won peace. And at this time, I ask unanimous consent to include in the record a statement from Brian Dooley on behalf of Human Rights First, a statement from Margaret Irwin on behalf of Justice for the Forgotten, and a statement from the Legacy Gender Integration Group. And I thank you, Mr. Chairman, and I yield back my time.
Thank you very much, Jim. Good. I appreciate your comments and leadership. I'd like to now introduce a very distinguished panel, beginning with Mark Thompson, who's the CEO of Relatives for Justice, RFJ, an Irish-based NGO that provides supportive services from human rights legal advocacy to professionally accredited trauma counseling and psychotherapy. Mark is first and foremost an advocate for human rights and accountability, justice for the most impacted and marginalized by over 3 decades of conflict in Ireland. Mark is responsible for the strategic development and management of Relatives for Justice and has overseen the growth of the organization from a successful and dedicated voluntary campaigning group in 1991 to the regional professional human rights advocacy and support organization that it is today, setting the bar for best practice for victims and survivors of conflict in Ireland. With Mark as its CEO, Relatives for Justice has become an internationally recognized and highly regarded human rights NGO. He has made representations on families' behalf before the U.S. Congress, the UN, European Parliament, European Court, as well as to governments in both Ireland, Britain, and across the globe. We will then hear from Geraldine Finucane, who is the extraordinarily brave widow of murdered human rights lawyer Patrick Finucane, who has testified numerous times before Congress. Pat Finucane, a well-known defense solicitor, was 39 when he was shot by loyalists from the UDA on February 12, 1989, as he and Geraldine and their 3 children ate Sunday dinner at their home in Belfast. Geraldine herself was wounded in that attack and thus doubly a victim of terrorism. After it was proved that this there was a collusion between the security forces and the killers. The British government apologized, and she talks about that briefly in her testimony when David Cameron did so, but again, refused to hold a public inquiry, which they had promised. In 2019, the Supreme Court of the United Kingdom ruled that an effective investigation into his death has not been carried out. Geraldine and her family continue to campaign for a public inquiry into his murder. And that means many of us over here in Congress not only are for that, we demand it. Alan Mcbride is co-coordinator of WAVE Trauma Center. He is an economic unionist and a strong Europeanist with views have been shaped by the various experience he has been through. Raised in a loyalist housing estate, his father was a member of the UDA. In 1993, Irish Republican Army bombers killed Alan's wife, Sharon, and her father, Desmond Frizzell, in their fish shop. That bombing killed 7 other people, including elderly and small children, and injured nearly 60 more. That incident led Alan to work with victims of the Troubles. For the past 13 years, has led the campaign for the injured pension, which made it into law in 2020. Then we'll hear from John Boucher, who is recently retired Chief Constable of Bedfordshire Police. He is currently in overall charge of Operation Canova, which investigates allegedly complicit state actors. He undertook investigations into the murder of 3 RUC officers in October of 1982, leading to a shoot-to-kill allegations and the death of a woman shot in 1972, which the family claimed was a result of security forces activity. He has been requested to take charge and review in the Glenang Gang, which is estimated to potentially involve over 100 extrajudicial murders. John is respected for his victim-focused approach, putting families at the center of his investigation and giving them a voice. He has appointed Victims Focus Group, an independent steering committee group of respected individuals to ensure transparency and accountability. This has been groundbreaking in Northern Ireland and welcomed by all stakeholders. As a chief constable, John built trust and new relationships with communities on a scale not previously experienced in force, and led Bedfordshire Police to be the most improved police force in the country. Then we'll hear from Louise Mallender, who is a professor of law at Queen's University Belfast School of Law and legacy theme lead in Senator George J. Mitchell's Institute for Global Peace, Security, and Justice. She is appearing before the Lantos Commission in her capacity as vice chair of the Committee on the Administration of Justice, a human rights non-governmental organization in Northern Ireland, due to participating in the strike action that is being held across universities in the UK. Just parenthetically, on many trips that I've made to Belfast, in addition to see Geraldine and many others there, including people from the RUC, with whom I had many arguments with, I would always meet with CAJ for their insights, which were always extremely well-focused and incisive. With her broad interest in international human rights law, international criminal law, and law and politics and political transitions, Louise has a significant research expertise in amnesty laws. This includes creating the Amnesty's Peace and Conflict Database, which contains detailed information on 289 amnesties used in response to conflict and peace processes around the world since 1990. Her monograph, Amnesty's Human Rights and Political Transitions, was awarded the 2009 Hart SLSA Early Career Award and was jointly awarded the 2009 British Society for Criminology Book Prize. We have tremendous witnesses who will bring additional light and focus on this ongoing issue, and especially with regards to the British government's attempt to just close the book prematurely with an end to this of statute of limitations. So with a statute of limitations law. I'd like to now turn to, again, our first witness. If there's any other members of the House online, I would. Who? Oh, Brendan? Are you here yet? Brendan Boyle from Pennsylvania? Well, he will be joining us shortly. So when he does, we'll certainly put him on. But Mr. Thompson, Mark Thompson, the floor is yours. And please, as I said earlier, I know it's usually 5 minutes, but I read your testimonies. They are so focused and incisive. If you want, take 10 minutes or so. We need to hear, and the world needs to hear what you've got to say. Mark?
Thank you, Mr. Chairman. The Good Friday Agreement heralded a new beginning for the people of Ireland and in the relationships between the islands of Ireland and Britain. Ending decades of conflict in which so many families experienced the loss of loved ones and where we witnessed the most egregious of human rights violations, hope finally replaced despair. This was especially so for those who bore the brunt of the violence, the bereaved and the injured, who still carry the trauma, the psychological scars and the physical wounds, and who also burden an absence of truth, justice and accountability. The agreement and the hope that it holds could not have been achieved without the role of the US administration as an honest and independent broker. Without doubt, peace in Ireland has been one of the greatest successes in US foreign policy in our lifetime. The diligence of US administration since 1998 and across the aisle bipartisan approach and interventions at critical times have kept hope alive and ensured the core foundations and principles of the Good Friday Agreement remain the bedrock for going forward and building a better, just and equal future for all our peoples. I want to commend your work in ensuring that the core democratic principles of access to justice, the rule of law, due process, human rights and equality are protected and seen as integral to the Good Friday Agreement. I cite Resolution 888, the letter to Boris Johnson by Representatives Boyle and Fitzpatrick, and the work of Representatives Neil, Keating, Kildee and many others, and indeed this hearing co-chaired by Representatives Smith and McGovern. Your actions have authority and resonance beyond your shores and are a reassurance to those of us in Ireland who continue to face persistent British government bad faith in respect to key pledges of the Good Friday Agreement and indeed subsequent international agreements that flow directly from that agreement. I refer to the Stormont House Legacy Agreement. Hope in the Good Friday Agreement was also underpinned by human rights, the European Convention on Human Rights. The rights of those bereaved, injured and who suffered appalling injustices must now be firmly based upon and subject to an adherence to international legal obligations and law, treaties and conventions the UK has long subscribed to but has not adhered to. Unfortunately, this non-adherence continues. The European Convention on Human Rights, incorporated into domestic legislation in the form of the Human Rights Act as part of the Good Friday Agreement, provided many victims and survivors with agency and law to ask questions and seek answers about the circumstances of the murders of their loved ones, many of which were never properly investigated, and to challenge impunity and immunity. Since 1998, victims can seek human rights compliant investigations and inquests into the murders of their children, their parents, their spouses and partners, and their siblings. Investigations that should be robustly independent, publicly transparent, completely thorough, and compliant with the law in accordance with Article 2, the right to life of the European Convention. In the 24 years that have followed the Good Friday Agreement, and with law on their side, such agency has enabled families to make progress towards obtaining accountable justice. However, the UK government have mounted a rearguard action aimed at preventing any scrutiny of their actions, using sovereignty as a shield whilst deceitfully engaging in what for them are pretend talks on finding resolution as they run down the clock. Hiding behind the use or rather misuse of public interest immunity gagging orders, national security clauses and closed material procedures, otherwise known as secret courts, the UK government has managed to prevaricate and delay investigations, inquests, civil actions, and ultimately deny justice. Coupled with the deliberate withholding of resources, effectively starving coroners' courts, civil courts, and the police ombudsman, this twin-track strategy has resulted in halting justice and accountability, creating a logjam in the justice system. Over 1,100 civil cases are lodged in the Belfast High Court regarding legacy. Over 450 cases are with the Police Ombudsman's Historic Directorate, awaiting investigation. Approximately 80 killings across almost 50 inquests also sit. Legacy is the defining issue of our time and requires resolution through law, not amnesty. 1,400 plus conflict killings sit in cold storage within the PSNI's Legacy Investigation Branch. Even though the PSNI does not meet the requisite legal standards of independence under the law to investigate these matters. And meddling is rife, where all loyalties and protection of RUC handlers and agents involved in murders dominate and overshadow the supposedly new beginning to policing. Agreement was finally reached in December 2014 between the Irish and UK governments and the 5 main executive parties to the devolved executive. To unlock this logjam, under the Stormont House Agreement, details were published on 4 key mechanisms to address the past. A fully independent historic investigations unit with full police powers, an independent commission for information retrieval, an oral history archive, and an overarching implementation and reconciliation group examining the themes and patterns arising from the conflict. However, like most agreements involving the UK government, they began to unpicket before the ink was even dry. However, this compromise agreement still contains hope, and if implemented as agreed, can deliver. It is human rights compliant. Fearful of this, and on July 14, 2021, the UK published a command paper setting out its new way forward. Abandoning all previous pretense, and in a unilateral move, the UK binned the Stormont House Agreement and unashamedly set out their true intentions, which are to bring an end to all murder investigations, including investigations by the Police Ombudsman, to end all inquiries, to end all inquests, end all civil cases, and end disclosure of all files, including extending the powers of the Official Secrets Act to journalists, prohibiting investigative reporting on certain cases. Peace cannot be built on a foundation of lies and deceit. The Good Friday Agreement must deliver justice for this and future generations and have meaning based upon the primacy of the rule of law. The UK command paper and proposed bill to abolish rule of law norms and standards poses one of, if not the single, greatest threats encountered by the Good Friday Agreement. The UK proposals are a deliberate act of political vandalism on the Good Friday Agreement and rule of law, and an action akin to that of a rogue state. It is the very antithesis of everything the Good Friday Agreement represents. Accountability and the rule of law are most certainly at risk. This now requires vigilance and diplomatic intervention. Thankfully, the US remains engaged and is a guarantor of the Good Friday Agreement. We respectfully ask this Commission to encourage the US administration to convene a summit with the Irish and UK governments, all political parties, and victims' representatives to ensure the UK honours its commitments and agreements pledged in respect to the Good Friday Agreement and the Stormont House Agreement on Legacy, and that the UK upholds, not subverts, the rule of law. Thank you.
Thank you very much, Mr. Thompson, for your testimony. Without objection, your full testimony will be made a part of the record, as well as all of our other distinguished witnesses. It is now my high honor and distinct privilege to recognize Geraldine Finucane for such time as she may consume.
Mr. Chairperson, my fellow speakers, distinguished guests, ladies and gentlemen. On behalf of my entire family, I would like to thank you for this invitation to speak today and to testify before this commission. I can think of no better person to name this commission than the late Congressman Lantos, who worked tirelessly throughout his life to advance the cause of human rights across the world, surviving the horrors of the Holocaust in the course of doing so. I was delighted to learn that this commission was renamed in his honour following his death in 2008. His name has been associated with human rights in Northern Ireland and my husband's case in particular since my family first appeared to testify before Congress in 1997, and I'm very pleased that this is still continuing today. I would also like to thank my ardent supporter and my good friend, Congressman Smith, for his continued work on the case of my husband, Pat Finucane, and the issues of human rights and conflict resolution in Northern Ireland in general. As many people will know, Mr. Smith has been a keen supporter of and advocate for the development and enhancement of human rights in Northern Ireland throughout the peace process. His work and that of Congress in general has proved invaluable to all of the people in Ireland in maintaining and developing our peace initiative through the many challenges we have faced even since the violence has ended. I think the topic we are discussing is one of the most important aspects of the peace process, namely how we approach the past, how we deal with it, and how we move beyond it, without forgetting it or worse still, pretending it did not happen. This is something I know from my own personal experience. I am here today because of what happened to my husband Patrick, who was murdered in Belfast in 1989. As is now a matter of public record throughout the world, Pat was a lawyer practicing in Northern Ireland during the period of civil conflict that extended through 68 to 94. Pat worked on behalf of people from his community in Belfast who found themselves on the receiving end of the most atrocious violations of their rights at the hands of the British state. Pat's work brought him into contact with people who had been falsely accused, unlawfully detained, threatened, beaten, and sometimes killed by state agents. As a result of his innovative approach to the work and the many successes that flowed from it, Pat became a target for loyalist paramilitaries who perceived him as partisan and thus an enemy of the state. The false perception of Pat as being sympathetic to his clients' political beliefs, and even that he engaged in unlawful activity on their behalf, was fostered actively by the British Security Service, MI5, encouraged by the Royal Ulster Constabulary Special Branch, RUCSB, and the British Army's Covert Intelligence Agency, the Force Research Unit, FRU. It would not be long before Pat found himself enduring obstruction and hostility in his work. He was being told by people he represented of threats to his life by members of the Royal Ulster Constabulary. In 1988, just months before he was killed, a junior British government minister publicly slandered the reputation of human rights lawyers in Northern Ireland, saying they were unduly sympathetic to the IRA. Plans of an imminent attack on Pat's life were known to various British state agencies and the RUC, and I might add, on more than one occasion, but no warnings were ever given. We were left in a state of ignorance and were completely unprepared for the eventual attack that would prove fatal. That was Sunday, the 12th of February, 1989. An ordinary day for most, but for us, it was the day our world changed forever. Since that day, my family and I have travelled the globe seeking the help of others to uncover the truth behind Pat's murder. I have testified before Congress about the evidence in our case, as have my sons John and Michael. The first time Michael testified before the House of Representatives was in 1997, and both he and his brother, who are both lawyers, have gone on to speak about our case on many occasions. We believe the circumstances surrounding the murder are sufficiently serious to warrant the establishment of such an inquiry. We have succeeded in litigating the issue against the British government on several occasions, at both domestic and international level. Notwithstanding this, the British government has refused to establish an inquiry. It has blocked our efforts for years to try to dissuade us from continuing our campaign by means of constant delay and obstructions. In recent years, we have seen them try to take advantage of this delay by claiming the issue is too old and must be confined to the past. However, I think it is true to say that even in the midst of investigating so many cases of human rights abuses by Britain in Ireland over many years, the truth behind the murder of my husband still represents a genuinely shocking indictment. We now know that Britain is guilty of colluding in the murder of an officer of its own courts. The magnitude of this statement still invokes a feeling of near disbelief, because quite simply, it is true and we have proved it. In December 2012, the Prime Minister David Cameron addressed the House of Commons with a speech on the findings of a report dealing with British state collusion into Pat's murder. In Westminster, Mr. Cameron stated the following, and I quote, "The collusion demonstrated beyond any doubt, which included the involvement of state agencies in murder, is totally unacceptable. We do not defend our security forces by trying to claim otherwise. Collusion should never, ever happen. So on behalf of the government and the whole country, let me say again to the Finucane family, I am deeply sorry." End of quote. However, even with this public apology in its own Houses of Parliament and the recognition of what it meant, the British government continued to refuse to establish a public judicial inquiry. And so I was again forced to litigate the issue, and in February 2019, I won my case before the UK's Supreme Court. It was declared that all investigations so far held were inadequate because they did not meet the requirements of the European Convention on Human Rights. We thought that this would force the British government finally to establish an inquiry. Instead, they refused and are now embarking on a course of action that would not only preclude an inquiry into Pat's case, but all cases involving the conflict in Northern Ireland. Article 2 of the European Convention on Human Rights protects the right to life and requires that an investigation be held when the state bears responsibility for a death. The Convention identifies 5 criteria that make up a proper investigation. It must be prompt, public, independent, effective, and it must involve the family or next of kin. All of these criteria are designed to ensure that one overarching element is present in inquiries and investigations. That is accountability. The state must be accountable for its actions, and this is demonstrated through proper investigation that people can see and hear for themselves. In a modern democratic society that proclaims to hold the rule of law in high esteem, one would think that holding an investigation that meets basic human rights standards is the least we can expect. However, it is these very standards that the British government seeks to erase by enacting new laws to prevent any investigations from being carried out. It is no exaggeration to say that Britain simply wants to sweep its actions and responsibilities under the carpet forever with no risk of any exposure. Inquests would be banned, civil actions halted, prosecutions discontinued. Police ombudsman investigations would be ended, and the legacy investigation branch of the Police Service of Northern Ireland would be abolished. It must be remembered that none of these measures have been proposed because of a lack of evidence of wrongdoing. In fact, it is precisely because of the existence of compelling and, in many cases, overwhelming evidence of British state complicity in abuses that the move to close down investigations and inquiries has been so comprehensive. My family and I will not cease in our efforts to prevent this from happening, and I know that we can rely on the support of our friends worldwide to ensure that this does not happen. It's not an easy thing to campaign for 33 years to uncover the truth. It has involved a great deal of effort, patience and resilience. At times, the stubborn refusal of the British government to establish an inquiry seems insurmountable, but we have found the strength to carry on. And it is also because of our support from friends worldwide that we've been able to do so. The US House of Representatives, the Senate, and even several US presidents have been an invaluable source of strength and sustenance when the struggle is hard to maintain. Your support has been unflinching, bipartisan, and a lifeline for us when progress has seemed impossible. My family and I cannot thank you enough for the solidarity you've shown to us and to the many, many families who struggle on today in pursuit of truth and justice for their loved ones. Proper examination of past issues does represent progress in contemporary society. It allows people to resolve traumas in their life and lay to rest the ghosts that haunt them and society as a whole. It is not always necessary to punish or to seek retribution. For many people, perhaps even most people, the truth about what happened is enough. We have not yet learned the full truth of what happened to Pat, but I believe we're getting closer, and one day, hopefully soon, I very much hope I will be testifying before this commission about achieving that goal. The recent turbulence in the world as a result of the COVID-19 pandemic has tested us all. Only now is the world emerging from its grip. If the pandemic and its effects have shown us anything, it is that only by working together and helping each other that we can meet and solve the great challenges of our times. We must ensure that the truth behind the events of the conflict is uncovered, preserved and presented to the world before it is too late. The legacy of conflict in Northern Ireland cannot be allowed to become clouded forever in secrecy. I have long believed that the truth must be told about the murder of my husband in order for the whole of society to have any chance of moving beyond conflict permanently. Far too many were taken from us far too soon for that to be allowed to happen. We must work together to ensure that it does not. Thank you very much.
Geraldine, thank you for that very passionate, eloquent, and for you, a champion of human rights with so much courage. Thank you so much for that. And your persistence is just incredible. So thank you, Geraldine. And we will never quit either. So I want you to know that. We have been joined by Congressman Boyle. I'd like to yield to my good friend and colleague.
Well, thank you, co-chairs Smith and McGovern. I remember joining you some years ago, Chairman Smith, when we had this hearing and Geraldine was with us in person. And I applaud you for your perseverance and for everyone else who is on this as well. Geraldine and Mark, it is nice to see you both, albeit it's virtually a little bit different than the last time I was with you, Geraldine, and the last time I was with you, Mark, here in Philadelphia. But the fact that this hearing is going on, even as we're still dealing with the 24 months now, basically, of the COVID worldwide pandemic, shows that our perseverance will continue. But when it comes to perseverance, no one embodies that more than you, Geraldine. And so it is, I echo everything that Chairman Smith just said. You know, I can't believe that we are still here having to push for this. And in fact, since the last time we held a hearing on this matter, things have even taken a big step backwards, I'm afraid to say. As colleagues of mine in Congress have expressed over the last couple of months, myself included, I am very disappointed that instead of fulfilling the promises set forth within the Stormont House Agreement legacy laws, the British Parliament and this British government is planning to take us backwards in seeking to institute a ban on legacy inquests and prosecution of former soldiers who served in Northern Ireland. These steps will not only prevent a pathway to justice, but will also strip families of their legal rights protected under European law, as well as the Good Friday Agreement. Now, just to remind everyone, it was in 2014 that the British and Irish governments, along with the Northern Irish political parties across the spectrum, that they reached the agreement that came to be known as the Stormont House Agreement. They pledged in that agreement to create 4 new legacy bodies. Of critical importance was the Historical Investigations Unit, the legacy body tasked with investigating the lingering and controversial killings that took place during the Troubles. The aim was to finally deliver justice to the bereaved of the conflict by providing human rights compliant investigations. Back in September, I wrote a letter to Prime Minister Johnson that was signed by more than 35 of my House colleagues from both parties, including co-chairs McGovern and Smith, urging Parliament to re-examine their proposals, reverse their decisions, and instead reaffirm their commitment to the Stormont House Agreement. For decades, the British government has made public commitments to get to the truth and foster reconciliation for lasting peace. But when opportunities to actually do so have arisen, the British government has instead, most of the time, engaged in years-long disputes and never engages in public inquiries. That's why progress in investigations has been so incredibly slow. There are still remarkably about 1,700 conflict-related cases awaiting investigations. This represents a simple lack of respect for the pain and suffering endured during the Troubles. It's also quite clear that no community has a monopoly on grief. The best way for all of us to move forward is to finally get the truth on these matters. Thank you, and with that, I'll yield back.
Mr. Boyle, thank you very much for joining us and for your great comments. Really appreciate it. I'd like to now yield to Alan Mcbride, who is the coordinator of WAVE Trauma Center, such time as he may consume.
Okay, thank you, Mr. Smith, and thank you, Mr. McGovern, and also the Land Trust Commission and the Friends of Ireland for the opportunities to come and to testify tonight. And I also want to just put on record certainly my gratitude for the American government, particularly during the time of the 1998 Good Friday Agreement. I think that probably the greatest gift to Northern Ireland, well, apart from Kentucky Fried Chicken and Coca-Cola, but I think the greatest gift perhaps was George Mitchell, who chaired those talks and who brought about the great changes that we have witnessed in Northern Ireland, although sadly we still do not have the society yet that we wanted to see happen back in those days. I can remember actually that night, Good Friday 1998, very fondly. I was actually at a cinema with my friend Rodney, and I remember we came out and it was all happening just close to midnight, and we headed up to Stormont, and we watched scenes which I thought would never ever happen in my lifetime, as we were on the threshold of something completely transformative and miraculous. And you know, 24 years on from that night, I suppose I look back with a certain amount of regret that we haven't really seen the progress, certainly in terms of the society that I had envisaged at that time, materialize. I had lost my wife just 5 years previous to the Good Friday Agreement in 1993. She was a young woman who just happened to work in the health service, but she also helped her father out in the family fish shop business, which happened to be on the Shankill Road. Where the fish shop was directly beneath the UDA headquarters on the Shankill Road. And I suppose one of the great sadnesses about Northern Ireland is the complacency that people had experienced during the lifetime of the Troubles, because whenever the Troubles kicked off in 1969 and in the early 70s, the things that were happening truly shocked us. There was maybe 300-400 people per year being murdered, and those things were truly shocking. But by the time we moved into the 80s and the 90s, those things started to shock us less. I guess we just got used to the fact that there was a conflict. And so if somebody had sat down with my father-in-law at some stage and said to him, you know, you want to think about where you're putting this fish shop, because where it is on the Shankill Road is in a really bad spot. Those UDA headquarters are probably going to be attacked at some time, and you maybe just would think about maybe relocating. But nobody ever had that conversation with us. We had become complacent. We just got used to the fact that there was a UDA club above the fish shop on the Shankill Road. And then, of course, on the 23rd of October 1993, our luck ran out when the IRA came onto the road. They walked into a fish shop. They were dressed as two fish delivery men. I know for a fact that my wife would have spoken to them, because her mother, Elsie, had stepped out of the shop to get the lunch in, and her father never served in the shop. He was always out the back cooking the beetroots and the various other things that they sold in the shop. So my wife undoubtedly would have been in the shop and would have greeted those two young men when they came into the shop with the bomb, and they looked her in the face, and then they left that bomb on the counter, and they killed her father, one of themselves, and 7 other innocent people. And you know, those days, I often think about those days. It was actually Sharon's. It wasn't Sharon's turn to work that day. She shared the duties of working in the fish shop with her sister, and it was her sister's actually turn to work that day. But her sister got invited to a wedding and couldn't go, and asked Sharon if she would fill in at the last moment. I also worked actually as a butcher at the time on the Shankill Road, just on the next block down, and quite often I would have been in the shop at lunchtime when that bomb was went off. But that particular Saturday, I had got a very rare day off, and so I wasn't there. So I guess fate comes into play in all of these things. But my wife was murdered that day, and I had to bring up my daughter alone. It was just me and her. And last year was a particularly difficult year for me in that Zoe turned 30. And when she turned 30, she was older than Sharon was when Sharon was killed. And I think if there's anything that brings it home to me about the longevity of our conflict, and the fact that we've been fighting for so long to bring an end to the injustices that we have witnessed on all sides, then it was my daughter, for me, turning 30. You know, I believe that the Troubles in Northern Ireland were wrong, and wherever families were hurt, no matter whether they were Republican families or Loyalist families, no matter whether they were families belonging to the security forces, everybody needs their time in court. Everybody needs some sense of closure and some sense of justice. I have worked for many years with Geraldine and with Mark, and so I have complete solidarity and sympathy with them in their own particular cases and the losses that they experienced, and I stand full square with them in their pursuit of justice and the ending of impunity. I have been around the block quite a few times on this. I've been involved in most of the initiatives to look at the Troubles and bringing about some kind of closure, right from in 2002 with the Healing Through Remembering report, which I think was the first report into how we can deal with our past, on through into the Mcbride report, the consultative group in the past, to the Hass-O'Sullivan initiative, and more laterally then to the Stormont House Agreement. And all of those reports, every one of them came up with not just one particular mechanism for dealing with our past. They all realized that the conflict was messy, it was complicated, it was complex, and so they suggested a menu of options as a way forward. But every time we went back to the negotiating table, we seemed to come away with substantially less than what was there in the past. The last time we went to the negotiating table, of course, was the Stormont House Agreement, and that agreement had widespread support throughout Northern Ireland, both in politics and also within the victims and survivor sector. And so whenever the government then were to produce their command paper in 2020, it drove a horse and cart through the Stormont House Agreement. And so, you know, if there's anything that unites victims and survivors at the minute, it probably is that we need to get back to that agreement, and we need to oppose in whatever shape or form we can the Stormont, the government's command paper, because I believe within that, whilst it's not perfect, and I wouldn't suggest for a moment that it was, there were many things that weren't in it that I would like to have seen in it, and but there were some things in it that I think at least represented a positive way forward for Northern Ireland, and I think that remains to be the case. And so my appeal, I suppose, to this Human Rights Commission and to yourself, Co-Chair Smith and Co-Chair McGovern, would be to hold the British government to the proposals that were made in the Stormont House initiative. I'm also in favour of things that work, and obviously one of the big issues in the Stormont House Agreement is the Historical Investigations Unit, the HIU, and I suppose that's the one aspect of the Stormont House Agreement that has come under the most attack from the British government with their proposals for an amnesty. An amnesty just sends out completely the wrong message to victims and survivors. It sends out a very powerful message that the death of your loved one didn't matter, that those who murdered them, that they don't matter either, and that needs to be absolutely opposed in all its various forms. I acknowledge to being a member of the victims focus group that John Boucher set up in relation to Operation Canova, and so when it comes to looking at things that work, we've been working for some time now with the victims of steak knife and the other victims that Canova have been looking at, and we know that Canova has got answers to those families that they would never have got before. So when I think about Canova and I think about the HIU, a question that I have is can we take the learning from Canova and the sort of the skill set that John Boucher and his team brought to that and how they dealt with victims and survivors, and can that be rolled out into the Historical Investigations Unit as a potential way forward? By way of conclusion, I just want to say that Northern Ireland needs a process to deal with the past. It will not be all things to all people. There will always be people who will be skeptical. There will always be people who will be outside the room. People perhaps that are too damaged, too hurt, too mistrustful because of things that have happened. But we need to press on nonetheless with a process that works for the greater number of people. And there can't be, and there must not be, any amnesty to that. Our loved ones that died all those years ago, some more recently, need to be told the truth. And where the evidence leads to a prosecution, well then that needs to be that needs to be pursued. Because if it doesn't go down that road, can you imagine how you would feel yourself if you lost a loved one in these circumstances, murdered in cold blood, and you are being told that because of the passing of time, there can be no redress? How would the victims of the Holocaust feel? How would the victims of Rwanda feel? How would the victims of 9/11 feel? And more recent atrocities as well. We should never put out a message that the perpetrators of violence and of murder and mayhem can just get away with it. That should never be a message that anyone that cares about human rights, that cares about people, should support. So thank you for your time.
Mcbride, thank you very much for your testimony, and so sorry for your wife and your loss. I would just say, when there's cover-up involved, there's nothing benign about an amnesty when it's all about concealing facts that would hold people to account. So your points are very well taken. And this is a massive cover-up ongoing by the British government. I'd like to now yield to John Boucher, former Chief Constable, for whatever time he would like to use.
Thank you, Chair, and thank you, fellow panel members, for incredibly powerful and actually inspiring testimony. Mark, Geraldine and Alan. It does sometimes feel when you do this sort of work, you're following the footsteps of giants, and what you've all done is quite remarkable. And I'm in awe of the work that you do to help other victims.
Excuse me, Jonathan, could you just maybe get closer to the mic, or maybe we
Yeah,
could,
of course.
it's hard to hear you. I'm sorry.
Is that any better? Okay. I'd also like to thank the Commission for inviting me to talk today. I thought it might assist briefly. I know you set out, Chair, the inquiries I'm doing, but briefly to explain what I've been asked to do. Firstly, the investigation into the activities of the alleged agent known as Steak Knife and any others that committed crimes with him. That includes members of the IRA and members of the security forces. I agreed to do this in June of 2016. That's probably led to us to examine around about 90 murders. And I think it's important to say the victims of a lot of those crimes felt they didn't have a voice. There is often discussed the hierarchy of victims in the conflict. And these particular victims, because many of their loved ones were accused of being informants for the British state, often wrongly. These people who were killed included children and people with significant vulnerabilities and learning difficulties. But those families often don't feel that they can speak up because of the attention that it draws to the profile of their loved ones of when they were killed. Also, we're investigating the death of Jean Smith Campbell, a lady who was killed on the 8th of June of 1972. And her family won a legal judgment to ensure that an independent investigation occurred into that crime. And it's with great sadness as a police officer that I learned of the challenges over many years they had in getting information. And every time they did get some information, it appears there was a further fight to stop them from getting anything else with regards to an understanding of what happened to Jean. Then there's the murder of 3 police officers in 1982. Sean Quinn, Alan McCloy and Paul Hamilton. We began that in September 2019, and again, those police officers' families, and it's often not mentioned, but the families of the security forces have often not had any information whatsoever about what happened to their loved ones. And when I approached the solicitor for those families, they'd not heard from anybody in the authorities or the police for many, many years. And I think it's fair to say they felt incredibly let down, and they had a belief that their loved ones, those police officers, has effectively been sacrificed as part of the dirty war, if you like, of Northern Ireland. And then most recently, we agreed to examine the Glenang Gang, a group that had been identified as allegedly involved in a significant number of murders in the 1970s. And we've currently calculated that to amount to around 127 murders that we're examining. So in total, we're looking at around about 250 murders during the conflict. To assist in dealing with these, I established 3 independent groups to provide oversight, advice, really how we deal with victims, expert input around the investigations, and to ensure the investigations are conducted thoroughly, as well as they possibly can be, and in accordance with the European Commission of Human Rights directions. Each group's membership has considerable experience, either of legacy challenges, of champion victims' issues, or of leading complex inquiries. The independent steering group provides robust challenge and scrutiny of our approach and decision making. I established this group of internationally renowned policing leaders and investigators with considerable experience of complex and sensitive investigations. The group provides a diversity of thought and expertise, contributing significantly to both the independence and effectiveness of the investigations. The group has exceptional, almost unique experience of leading such investigations in politically challenging environments and of delivering truth for victims. The group includes Kathleen O'Toole, the ex-chief of Boston Police and Seattle Police, Mike Downing, the ex-deputy chief of Los Angeles Police Department, and John Miller, currently a Deputy Commissioner with the New York Police Department. The group meets quarterly, and I'm pleased to say, notwithstanding COVID, we're going to meet again in person in March. I also established the Governance Board, a group that provides further compliance with our activities around the European Convention of Human Rights. I established the Governance Board, who are responsible for making sure that the oversight of all of the functions of Canova are compliant with ECHR. The board do not have access to the investigative material that we provide. That's the remit of the independent steering group that I mentioned a moment ago. However, the board will ensure that that independent steering group and other groups that assist us function properly. It will review all the Canova public-facing reports that I produce ahead of publication to ensure that the legal and investigative due diligence has been properly applied, that the reports can be relied upon, and that they're robust and accurate for families and stakeholders alike. That board also meets quarterly. And then there's the Victims Focus Group, which Alan Mcbride mentioned, and of which I'm very grateful for him being a key member. This group provides particular challenge around our compliance of the convention with regards to how we support victims, how we inform victims of what has happened with regards to their specific cases. I was conscious of the role and rights of families and the next of kin, specifically required by the European Convention of Human Rights, and introduced this panel of independent and largely international experts to provide advice and scrutiny of how the investigation was conducted. The Victim Focus Group have met families that we deal with, and they've conducted a survey of those families. And last year, the Victim Focus Group produced a report on the progress and the work of Canova. This report has been shared with the Commission. The Canova approach is to place families at the centre of what we're doing. Many families, including those from the security forces, feel that the authorities have failed them. Bereaved families often have little or no contact with the police, scant information about any investigation that was conducted, and were not even informed of inquests. Recognising that at times there were security reasons for these failings, it has led to significant mistrust for many families. Families want to be listened to, acknowledged, and told the truth of what happened. They want to know that their loss mattered, that what happened was wrong. It is a failing of all of us in authority that so many families believe that the authorities who are there to protect them and investigate these matters do not care about what happened. Their loss also feels as if it occurred only yesterday. If the truth is denied them, their next generation will carry on the fight for answers, and the past will not heal, and they are right to carry on that fight. Outcomes should not be judged by criminal justice processes alone. The criminal justice process should never be viewed as a comprehensive solution for dealing with the past. Legacy requires a commitment to and an openness towards families. The truth can still be uncovered for many. Some families do not want to revisit these traumatic events, and their wishes must be respected. The inability of the security forces to properly investigate cases, in part due to the threat, is of course well understood, and we should never forget their sacrifices. A critical success for Canova has been the agreeing of information sharing protocols with the leadership of the PSNI, the military, and MI5. We have recovered records other investigations previously commissioned were not provided access to. The key requirement for a comprehensive investigation is access to all of those sensitive records. Legacy requires three pillars: an absolute focus on families, high quality investigations, and unfettered access to information. The security forces are often of a view that any examination of legacy is of itself a criticism of them, and that disclosure of information represents a threat to national security. Neither is correct. It is what sets us apart as a democracy that, having been unable to deal with these cases properly at the time, that because of the danger that existed to everyone, we should now do what we can to give families the investigations they deserve. Addressing legacy was the missing chapter of the Good Friday Agreement. The determination of families to discover the truth is as strong as ever, and we can provide those families who wish it with the information that they want. Some commentators suggest the costs of such a process are prohibitive. They are not. The costs of not offering such a process to families is immeasurable. Canova has shown, undoubtedly, that legacy investigations are capable of being investigated, notwithstanding the passage of time, and families can receive information of what happened to their loved ones. Prosecutions are possible. Criminal justice outcomes will, of course, be rare, and such prosecutions need to be carefully considered for some families, as a criminal justice process might well bring unwanted and harmful consequences. Families have suffered enough. When families and stakeholders trust a legacy process, they will provide evidence and information that can assist in those cases being solved. And where government agencies are reassured about information handling and security arrangements of a legacy investigative body, they can and must share information with that body. And this will, of course, potentially lead to cases being solved. Through various independent examinations of Canova, subject matter experts in the UK and more widely have considered the investigative model of Canova as scalable for wider legacy cases, offering value for money, and has proven to have the support of victims and families. Mr. Chairman, you mentioned that the victim focus approach of Canova had won us many friends with victims and families. But those victims and families have seen every type of investigation before. What turns their head towards Canova is our unconditional approach to recovering the information that they've got the right to receive. And any efforts to withhold information on the basis of national security grounds should not succeed, and all information should be given to an independent legacy process who can then quite properly protect the information, but ensure that that information is not withheld on any grounds where it might be suggested that it's covering up wrongdoing or criminality. I'm happy to help the Commission in any way I can.
Chief Constable, thank you for your testimony, and thank you for doing the hard work of these investigations. It must be grueling, but thank you for that tenacity. I'd like to now yield to Louise Mallender, Professor Mallender, for her testimony.
Thank you very much, Chairman Smith and Chairman McGovern, for inviting me to testify today, and also for your continued support for the peace process in Northern Ireland. Thank you too to my fellow panellists for their really compelling testimonies. I've been fascinated listening to you all. The sweeping unconditional amnesty that for the troubles-related offences proposed by the UK government in July would be, I think, illegal, illegitimate, and more expansive in its legal effects than any amnesty granted in a post-conflict society in recent decades. I agree with what has been said so far, that these proposals would also be contrary to the Stormont House Agreement of 2014, which sets out a framework for a comprehensive approach to dealing with Northern Ireland's past. As you heard in my introduction, since 2003, I've been involved in creating an extensive database that has descriptive information on the scope and legal effects of amnesties granted around the world over many decades. This data has confirmed that amnesties continue to be used regularly to support peace building. However, these amnesties typically try to balance the need to prevent violence with the need to deliver accountability. They do this through limiting the scope of the amnesty in different ways and through imposing conditions on beneficiaries. The UK's proposals deviate sharply from this international best practice in terms of their motivations, their scope, their legal effects, and the conditionality of them. So I'll go through each of those points now. So firstly, with respect to motivations, the decision to impose an amnesty at this stage, despite opposition from all quarters in Northern Irish society and from the Irish government, can't be justified as being necessary to ensure the peace. Indeed, as others have said, in an already unstable political environment, these proposals risk undermining the peace in Northern Ireland. Instead, it seems apparent that preventing the truth becoming known about the UK's involvement in criminality and human rights violations during the conflict is the primary objective of these proposals. This is clear from repeated government statements emphasising its commitment to protecting British Army veterans from what it terms as a repeated cycle of investigations. It's also clear from the sweeping legal effects of the amnesty and the weak investigative powers that would be granted to the proposed legacy institution. Secondly, the scope of the amnesty would apply equally to all troubles-related incidents committed by state forces and paramilitaries. I think it's worth bearing in mind that only 25% of amnesties introduced internationally since 1990 applied to state actors, which gives you a sense of how comparatively broad this scope is. In addition, the command paper does not refer to excluding any serious human rights violations. This means we can infer that the intention is that the amnesty will apply to killings and to torture. This, again, is unusual for amnesties to have no crimes limited from their scope. It's much more common for amnesties to exclude certain egregious offences or to otherwise try to narrow what can be interpreted as conflict-related crimes. Thirdly, the command paper suggests that the amnesty would apply automatically and without the amnesty persons having to do anything to receive or retain the amnesty. Any subsequent engagement by these persons with information recovery would be entirely voluntary. This approach removes some of the safeguards for testimony contained in the Stormont House Agreement, which envisaged that information recovery would operate on a confidential basis. But it also ensures that there's very little incentive for former security force personnel and paramilitaries to provide information. I think this is particularly problematic given the unilateral nature of the UK government's approach will undermine trust in these institutions. And I think it's unsurprising, therefore, that even Northern Ireland's Secretary of State has said he has very little expectation of paramilitaries participating in the legacy process that he himself is proposing. Adopting such an unconditional approach, again, would place the UK outside of established international best practice, given that only 37% of conflict-related amnesties since 1990 have been unconditional. Fourthly, the intended legal effects of this amnesty measure are deeply problematic. As we've heard already, the amnesty would immediately end current and future criminal investigations and prosecutions, including for the large number of cases that have not yet been effectively investigated. The measure is being pursued even though there is little expectation, even among victims, that criminal investigations today would result in more than a handful of viable prosecutions. In addition, due to the early release scheme, the maximum penalty that could be imposed for most troubles-related offences is 2 years imprisonment. Despite the difficulty in obtaining convictions, there has long been widespread support for keeping the possibility of prosecutions open. As we've already heard mentioned, this was reflected in the Mcbride proposals in 2009, in the House of Sullivan initiative in 2013, and in the Stormont House Agreement of 2014. The importance of keeping the possibility of prosecutions open, I think, is due to the significance that many victims and stakeholders place on the need for independent investigators to have full police powers in order to be able to obtain valuable information for families. The huge volume of information generated by Mr. Boucher's work, for example, provides an impressive example of the importance of such powers. And I was struck by his reminder that the truth can still be possible for many if the mechanisms were able to work effectively. The legal effects of the amnesty would also include immediately closing all coronial inquests, civil remedies, and police ombudsman investigations relating to legacy cases. Such sweeping impunity would be unprecedented on the international stage. Only 6% of conflict-related amnesties that I've uncovered have directly closed down civil remedies. And I haven't been able to find any that try to close down other forms of investigative processes for conflict-related crimes. As you know, the vast bulk of cases today are before the coroners, the civil courts, and the police ombudsman. Examples from recent months reveal how these institutions, using judicial or statutory powers, have been able to obtain evidence of significant collusive behaviour between police and loyalist paramilitaries, and to determine responsibilities of soldiers for killing civilians. These outcomes provide information and acknowledgement to victims. They enable victims to access compensation and make public information that is essential for reconciliation and for ensuring public trust in state institutions. Closing down these measures would deny victims access to effective remedies and would undermine the rule of law. Overall, as Co-Chairman McGovern noted, the UK government intends to introduce an amnesty that's far more sweeping than Augusto Pinochet enacted in Chile in 1978. Of course, Pinochet was an internationally reviled dictator. The situation with us is very different. The UK is a leading democratic state with a permanent seat in the UN Security Council and membership of the G7. But if the UK enacts this broad amnesty, it will send a dangerous signal to other states that they too can legislate for impunity. Congressman Smith mentioned that the UK is a strong partner to the US in the promotion of human rights and democracy around its world. If it enacts this measure, its legitimacy and ability to do that on the international stage will be substantially eroded. I think the consequences of that would be damaging not just for us in Northern Ireland, but for adherence to human rights around the world. Successive US administrations have played a pivotal role in achieving peace in Northern Ireland. And since 1998, as we've heard, the US Congress has consistently supported our peace process. Going forwards, I'd like to encourage the United States to continue to do that, and particularly to maintain its position that any future trade agreements with the UK are contingent on Britain continuing to respect the Good Friday Agreement, and to emphasise that the US would view legislation to enact the proposed amnesty as undermining the agreement's human rights safeguards and criminal justice reforms. We would also like to ask that the US continues to urge the British and Irish governments and all political parties to abide by the commitments in the Stormont Agreement and international human rights law, and to continue to work collectively to address the legacy of the Troubles. So thank you once again for inviting me to testify and for your support for human rights in Northern Ireland. I look forward to answering your questions.
Professor Melander, thank you for that very incisive review of the consequences, as well as, many of our witnesses have talked about true intentions and motives, and I think the motives are very dark on behalf of the government. Going back to the very beginning, these kinds of issues have been raised about, even Peter Corey, when he did his very fine work on these issues, including, I have it right here, Billy Hamill, Rosemary Nelson, Robert Hamill, Billy Wright, I should say, and of course, Patrick Finucane. We had, before my subcommittee, Peter Corey testify, and he was a tremendous former justice of the Canadian Supreme Court. I spoke for an hour without a single note, and it was like a lecture of the highest caliber. And then a year later, he also provided testimony to our hearing and pointed out, because then the subterfuge by the British government was to change the public inquiries law so that ministers would have veto power over information under their jurisdiction that wouldn't be, no one would be allowed access to. And as the chief constable said before, and others have said, access to documentation information is critically important, or else you get a whitewash. You get information that is not going to be anywhere near complete or accurate. So, just for the record, and I'll add it to the record again, Peter Corey wrote to my subcommittee back in March 15th, 2005, to change the ground rules at this late date, this is 2005, is unfair. It seems as well unnecessary, since the security of the realm would be ensured by the courts when the issue arose in a true public inquiry. He talked about how, again, the minister's actions, whose minister was to be reviewed by the public inquiry, We have the authority to thwart the efforts by the inquiry at every step. They have veto power. Now fast forward to today, and we're talking about a complete sweeping total amnesty, which is nothing but a synonym for that is cover up. There is no statute of limitation when it comes to murder and torture, as you pointed out, Professor, in your statement, and as did the Chief Constable and others. So I guess one thing that I thought was very, Geraldine Finucane talked about how Article 2 of the European Convention on Human Rights makes clear that a proper investigation must be prompt, public, independent, effective, and must involve the family or next of kin. This is none of those criteria fit. And I do hope the British government is listening, because this puts them, raises questions about their own credibility, undermines their commitment to the rule of law when it doesn't suit them in terms of who is implicated and how far up the chain of command does all of this go. There needs to be, a complete openness about this, and that has absolutely not been forthcoming. And this is the final nail in the coffin of cover-up that they're engaging in. So maybe if you could, any of you who would like to, anything you heard from the other witnesses, respond to, speak to this cover-up issue, which I think is very damaging to the British government. And again, this raises questions about the criminal justice system of the UK itself, as you have said, Professor. So maybe we can start with Geraldine, if you don't mind, and then any others who would like to speak or add anything, again, having heard each of these distinguished panelists testify. Geraldine?
I must say I've been very, very impressed by all my co-speakers today. And everybody seems to be on exactly the same wavelength, that this proposed new law is just not the way to go. Not the way to go in Northern Ireland, and not the way to go internationally, worldwide. It's just arrogant. And it is something that the British government have done many times before. When Pat was alive, his clients were being held in custody for 48 hours, 72 hours with no access to a lawyer. They were being detained without any legal redress. And when Pat and other lawyers started to challenge this, the British government changed the law and brought in the Emergency Powers Act so that they were acting within the law once again. And why I bring this up now is because I feel this is what they're doing again. They don't want to deal with all that they have been doing up until now. So they're just going to change the law, and then they won't have to deal with it. And I think everybody is much more astute now, much more aware. I think Alan was talking earlier on about people becoming complacent and not asking questions. I think we've all woken up. And I think maybe that is why everyone, no matter what side you're on, is really against this new proposal and is seeking help from yourselves and from others who have some influence.
Before going to the other witnesses, this is shocking, with all eyes focused on the Ukraine, eyes focused on the Beijing Genocide Olympics, and all of the other crises that are just percolating all over the globe. Perhaps under some cover of all of those crises, the British government perhaps thought people would notice. Not only are we noticing, it's with a profound sense of disappointment. What they're doing with this cover-up is an embarrassment. And I hope there's some MPs who will push back against this in the House of Commons, because to me, this is outrageous. What's happening? So if some of our other witnesses, yes, I see.
Yes, thank you, Mr. Chairman. It's probably important to point out that the UK government stand alone, even within the UK Parliament. the British Labour Party and all the other parties in opposition are in opposition to these proposals also. I think the former spokesperson for the North of Ireland, Louise Haig, spoke to the ad hoc committee to Congressman Walsh and Congressman Morrison about this. But I want to raise some issues as well in respect to some previous investigations, because investigations oftentimes lead to more questions from families. Sir John Stevens, who was the former head of the Metropolitan Police in Britain, conducted 3 major inquiries into collusion, including his 3rd inquiry that touched on the murder of Pat. And in the course of the 14 years of those 3 inquiries, which was up until the bombings in London of 7/7, the largest police investigation in British policing history, he revealed in 2013 that he arrested 210 people who were involved in paramilitary organisations and involved in murder and bombs and shootings and so forth. Of those 210 people he arrested, he told a UK parliamentary committee that 207 of them were participating agents working for the British state inside those illegal organisations. And families want to know the depth of that. Also, when David Cameron refused to give an inquiry into the murder of Pat Finucane, they appointed a paper review only of the papers, by Sir Desmond de Silva, himself a member of the British Conservative Party and a legal figure. And in his report, even though it was a paper review, he said that 85% of the intelligence in the hands of loyalist paramilitaries, the UDA, for targeting people for assassination came from the British security and policing agencies themselves. And more recently, the police ombudsman has produced 3 reports that have been delayed into over 50 murders and attempted murders. And those reports, there were significant delays on those. There was a rearguard action against those. The former police ombudsman who did the bulk of the work in those reports, Dr. Michael Mcguire, had to take the PSNI to court the first time of an unprecedented situation where one statutory criminal justice agency took another to the court to get access to intelligence to conduct the investigations. Over 100 requests of his investigating officers were blocked by police. And he said publicly at the time that he wasn't going to allow the people who were the very subject of his inquiries and investigations to determine precisely what information he could get and not get to conduct those inquiries. And this is the latest report that was produced by the police ombudsman last week into 27 murders and attempted murders in South Belfast. And the object is to stop reports like this, to stop the work of John Boucher, to stop the work of academics, to stop the work of lawyers, to stop the work of families. And it's so important that you stand with us in terms of standing up to the British government and saying this is not acceptable, because truth will out and families do demand it and society demands it. Healing demands it, and it's not just as simple as drawing a line onto the past. We have to have accountability and confidence in the institutions of justice and the rule of law. So thank you again, Mr.
Mark,
Chair.
thank you. And that's exactly why I called this hearing. And I thank you. I think, Alan, did you want to comment?
Yes, thank you, Co-Chair Smith. I'm not sure how to get into these things, whether there's a wee button you press to raise a hand or you just actually raise a literal hand. So I'm just raising a little hand. Can I say to you, I mean, the whole notion of cover-up, I think, of course, is not, in my view anyway, not just in relation to the British government. And there's no doubt about this, that they have tried to cover up many atrocities, from Bloody Sunday to Ballymurphy, etc., etc., etc. And I've got to know a lot of those families very, very well. And I know that the narrative that I was taught as I was a child growing up about how these atrocities were often gunmen and gunwomen who were out in the streets trying to kill British soldiers, and that all the British were doing really was retaliating. And it wasn't until I was a much older person and got to know some of these families that I realised that in these cases, these were innocent people that were just absolutely terrorised and assassinated by British soldiers. And where that happens, that absolutely needs to be called out and needs to be investigated. But they're not alone. Because I know from my own perspective, both Republicans and Loyalists have also tried to cover up atrocities in the past. I mean, Martin McGuinness and Gerry Adams haven't been particularly forthcoming in relation to Claudy or indeed the murder of Jean McConville. Loyalists in relation to the murder of Bobby Moffat and countless others, Raymond McCord, etc., etc. So I think there's a lot of people out there with vested interests that don't particularly want the truth to be interrogated. I know that both Sinn Féin and the DUP have come out against these proposals publicly, but privately, I wonder sometimes if they're really that upset, because I think it must be music to their ears to hear that these past atrocities carried out on all sides are not going to be investigated. So I think that we need a process that actually goes into all of these things. Doesn't matter who you are or what background you're from. Death is death, murder is murder, and no matter who carried it out, whether it's a British soldier, an IRA man, or a UVF man, they all need investigated, and all of the families need an avenue to the truth.
Anybody else want to comment? What is this?
May I come in,
Yeah.
Chair Smith? John Boucher.
Yes, Chief Constable.
Thank you. I just wanted to possibly offer a little balance. I don't know, because it's important, I think, to make clear that in Operation Canova, as far as I can establish it, and we have access into MI5, into the military and into the PSNI, direct access. It's something I insisted upon, having spoken to a lot of those who previously led legacy investigations. We are getting the access to the material that others did not receive. Now, I think it's realistic to suggest that some of that access that wasn't provided years ago was because of the proximity of those investigations to the conflict. And there was a lot of people in those organisations, leading those organisations, who were affiliated to a side of the conflict. And therefore, they made it hard to get the material. And my experience has often been that the lawyers who represent those specific organisations, whose job it is to protect those organisations, not to help me or to necessarily help the families or to get justice, they work for those organisations. And I don't criticise them. They present a barrier to getting that material, and half of my battle has been to get past the lawyers to get that information. And I will say that in all of the investigations I'm doing, we are now getting that flow of material. However, it didn't happen straight away, and I'll be reporting probably during this calendar year around some of those challenges. But it is my assessment that the leaders of MI5, the Director General, the Chief Constable of the PSNI, and the leadership in the Ministry of Defence are now ensuring that we get the access that the families deserve, and legally that those authorities are required to give. And I spoke with Rennie Pomerantz, who was Judge Corey's deputy, and a lot of the misgivings come from the way investigations were treated and responded to previously. So Judge Corey, I know, and he spoke about it publicly, their files were actually taken when they were in London because the authorities felt that Judge Corey didn't have sufficient security in place to hold such sensitive information. Now, call me old-fashioned, but I think the best thing would have been to speak to Judge Corey and help him with his security rather than take his files away. Fortunately, he'd back material up. John Stevens, I speak to regularly. He's a good supporter of Canova, who conducted 3 inquiries that Mark referred to. 2 of those reports that he did, which I've read all of these reports, still remain at top secret. Now, material in those reports predominantly is not sensitive. It should be released. And we've got to get past this culture of information retention and secrecy. And I remember speaking to Judge Smithick, who conducted inquiries as a result of Judge Corey's work. And Judge Smithick said to me, "John, when does something stop being a national security issue?" And all of these historical challenges, I do think there is an emerging opportunity. There is an acceptance with a lot of people in senior roles in these organisations that hold the material that may offer an opportunity to actually properly investigate these legacy cases. But because of the time that's passed, this, I think, could be a last chance saloon to do this meaningfully. And I hope the British government, in some of the comments they've made about being authentic and genuine in wanting to provide more information for families, I hope they mean that, but I think they need to demonstrate it as opposed to talk about it with acts of good faith. And I am of the view, I'm a old-fashioned detective, that the rule of law has served us well for a long time. And I am extremely nervous around stepping away from a criminal justice process. But I caution this. There are some families that I deal with who it would be detrimental to them to have a prosecution in their case because of the circumstances of their loved one's death and where they live in the community they live. And there needs to be a way, that, and I'm sure there is, by the way, I've certainly made certain suggestions around this, there needs to be a way to appreciate those issues for those families so that we don't immediately go to prosecutions if all the evidence is there. We take into account the nuances for those particular victims. And we were bold enough to release people from prison who are involved in some of the worst atrocities in modern British crime. We completely overhauled the policing system in Northern Ireland. We placed people who are associated with being involved in the conflict into the power sharing agreements to achieve the Good Friday Agreement. We need that same sort of support and thinking towards these victims and their families. And I do think there is a real opportunity to get this right. A lot of it, I do feel, falls on the shoulders of the British government to take a different direction to that they're currently taking. Thank you.
Thank you very much. We've been joined. Oh, yes, Geraldine.
Just on a totally different track, I've just realized that my device is seriously losing power, even though I've got it plugged into the mains. So if I suddenly disappear, my apologies.
Dear Constable, we had Chris Patton testify at one of my previous hearings, who obviously reorganized the PNCI. So thank you for mentioning that, because I think that's very important. But it's got to be done right. Everything cover up is never a solution. We are joined by one of my distinguished colleagues, Sheila Jackson Lee, who has asked if she could speak right now. Congresswoman Jackson Lee. I guess we lost her. I'm sorry. I'd like to now yield to our very good co-chair, McGovern.
Well, thank you, Chair Smith. I appreciate this. And thank you for this hearing. I want to thank all the witnesses for your excellent testimony. I mean, this is an important topic. And again, I want to thank you for your leadership, not just recently, but over a long period of time. And you have the respect of everybody on this commission. And certainly we want to be wind at your back in your quest for justice and accountability. I think what the UK is doing right now is especially disturbing because, quite frankly, I think the world expects more from countries like the UK, just like they expect the United States to be maintain a high standard for human rights and justice. And when countries like the UK kind of turn their back on truth and accountability, when they try to cover up a very violent and unfortunate past, quite frankly, that's a signal to a lot of other countries around the world that don't proclaim to be democratic countries that do not have a history of adherence to a rule of law that gives them license to cover up atrocities that their governments are responsible for. So this is incredibly important, and again, it's something that in this Congress there's bipartisan support for all the things that you have talked about here today. And I think that's an important message to the British government as well. The UK is a strong ally. We have good relations. We cooperate on a lot of things, but that doesn't mean we are going to be silent in the face of what they are trying to do right now. I just have a couple of questions here. So the last time this commission took up accountability for Northern Ireland, it was to discuss the need to incorporate gender principles into the design of truth, justice, and reparation programs. I mean, Mr. Thompson, would you be able to speak to the potential gender impact of the government's proposals to, quote, draw a line under the troubles? Or would anybody else like to address this?
Yeah, no, thank you. And a previous colleague of mine, Andre Murphy, along with Mary McCallan, gave evidence to the Tonlantis Commission a number of years ago. UN Security Resolution 1325 and CEDAW, the Committee Against the Elimination of Discrimination Against Women, have all cited the kind of particular impact on gender. And I'm very conscious talking about that with Geraldine here. I think Geraldine epitomizes, as a leader, the mothers, the women, the spouses, and people that have been left behind, because over 91% of those killed have been males, and the majority of people injured have been males. So it leaves behind families. And I think Geraldine, many people look to Geraldine in terms of a beacon of hope, someone that has been in incredibly difficult situations, particularly strong, has raised a family that is admirable and admired right throughout our country and far afield. And the stance that they have taken for human rights and for justice in their own case and for many others, because an inquiry into Pat will ultimately touch on the policy of collusion more widely. But there are many, many families and women, and how they experience trauma cognitively is very much different. But they are the people who were, in the absence of their loved ones being killed, had to pick up the pieces, had to keep the home, had to do the homework, had to rear the children, had to find the kind of the earnings to keep the home going, and in birthdays and in Christmases do all those things that women take a leadership role in and do mostly and bestly in society. And so the UK have refused to recognise that what happened in the north is a conflict, and they have not adopted Resolution 1325, and we would call on them to do that. And Relatives for Justice has been involved in, along with the Gender Principles group of academics and lay people and activists. And we do think that any process to deal with the past must at its core have a gender focused lens. So thank you for that.
I don't know if anyone else wants to add. I have a couple more questions. Last month, Human Rights First warned about increasing social media attacks against Colin Harvey, a professor of human rights law at Queen's University in Belfast. This follows on their 2017 report on the intimidation and vilification of human rights lawyers working on legacy cases in Northern Ireland. In 2018, there were serious concerns about online attacks against defenders, especially women and LGBTQI activists. So what is the current situation for human rights defenders, including lawyers in Northern Ireland? Are they able to do their work without fear or threats or attacks? I open this up to anybody who wants to take it on.
Maybe I can come in on this,
Okay.
Chairman.
Yeah, go ahead.
Colin Harvey is my colleague at the Law School of Queen's, and I think you're
Yeah.
quite right that over a number of years he has been subjected to different forms of attack on social media and print media, and it has had implications, I think, on different ways in which he can do work. So recently it's come to light that he was barred from certain appointments in relation to the Bill of Rights due to objections around his academic research. I should say his academic research relates to constitutional law and the Bill of Rights in Northern Ireland, of which he is a well-respected expert, and he carries out those roles with dignity and respect for all parts of the community. So I think in that particular example, we can talk about that, yes, the climate, the nature of the debate does inhibit people's work in particular ways. I think also over a number of years, there have been attacks on lawyers in Northern Ireland, describing their work as vexatious. And I think this speaks a little bit to the earlier discussion a moment ago about cover-up, about the myths and narratives that are used to justify the British government's proposals. When I read the command paper, one of the things that I was particularly struck with was how the justifications put forward for many of the policy choices in it were not grounded in evidence or facts. There's the idea that there are imbalances, that the prosecution service perhaps isn't acting in a way that's fair, that different processes aren't operating the way they should be, but there's no presentation behind that to supporting those evidence. And I think because there isn't any. So I think there's different ways in which we're seeing this, and it is tying into some of the challenges we have around legacy.
I just have one other question here because I have to go to another hearing, but I'm an original co-sponsor of a bill, HRES 888, which is expressing the hope for justice for the victims of Bloody Sunday, which opposes any attempt by the British government to implement amnesty or statute of limitation laws. In Brian Dooley's statement for the record, he recommends that members of Congress invite British members of Parliament to explain the government's proposals, and that when they travel to the UK, meaning when members of the US Congress travel to the UK, that they visit Northern Ireland and meet with the families still searching for justice. You know, there are lots of congressional travel that goes through the UK. You know, sometimes it's a destination point, sometimes it's a couple of day layover where they meet with government officials. I guess I'd like anybody's opinion on what are the most important actions the U.S. Congress could take at this time to support ongoing efforts to ensure accountability in Northern Ireland. I mean, clearly, there's a question as to whether accountability and truth and reparations and justice will proceed as we all want. But I'm just trying to think of concrete actions. We're doing this hearing today. I mean, members of Congress travel to the UK all the time. Administration officials travel to the UK all the time. What should we all be doing that we're not doing right now that might increase pressure in a way that will move us in a very different direction here?
Co-Chair McGovern, could I just say a few words? I mean, there's no doubt that American influence in Northern Irish politics has taken a back seat in more recent times. Certainly it wasn't what it was under President Clinton.
Right.
The big issue that we're facing with relation to the government command paper is the fact that the Conservative government have quite an overwhelming majority in the House of Commons, so they can effectively push through these proposals almost uncontested. Certainly the other political parties don't have the numbers to prevent them from doing so. The American government and the Biden administration, I think, is extremely influential at the minute because, as you know, with Brexit, the British government are going to be coming to you guys seeking all sorts of lucrative trade deals. And I would absolutely, at every corner, be raising these absolutely abhorrent, objectionable, legacy proposals. I mean, you've got a good cross section of people on the panel tonight. They're talking from various different angles where we're not all agreed politically. But the one thing that unites us all is that we're absolutely opposed to these abhorrent government proposals. And so whatever you can do to send out a very, very powerful message that these proposals drive a horse and cart through the Stormont House Agreement. They are not in keeping with the principles under the Good Friday Agreement, and potentially they run the risk of re-traumatizing families for generations to come. Because what I'm witnessing in Northern Ireland at the minute is when atrocities happened and people started campaigning, it was quite often the partners of people that were campaigning. But nowadays it's their children and sometimes their grandchildren if we don't get this resolved in a way that brings satisfaction to families, this will go on for generations to come. And the way to do it is not to simply draw a line in the sand and to say, that's it, it's over, forget about it.
I just want to say, I think that's an incredibly important point. I've done a lot of work on human rights in Central America, and a couple of years ago, I went down to El Salvador, where I spent a lot of time in the 1980s, to help launch a campaign that was committed to finding those who disappeared in the conflict, that their families never knew what happened to them. And what struck me when I went to this forum were that the people that were in the audience who were holding up pictures of individuals who had disappeared in a war in the 1980s, some of them weren't even born in the 1980s. They're, children, grandchildren. So the notion that you can just forget about it all and that it goes away, well, that doesn't happen, right? I mean, unless there's truth, generation after generation after generation. I look at the struggle to recognize the Armenian genocide. All those who survived are no longer with us, but their families, their children, their grandchildren, their great-grandchildren all continue to take up the torch. So the governments that think you can just cover all this up and move on, there's no indication that happens. The wounds continue, and so I. But does anyone else have anything to add before I yield back? Yeah, go ahead. Yeah.
Chairman McGovern,
Mr. Thompson, yeah.
You asked in terms of what you could do. In some regards, this in itself is part of a fact-finding mission, the hearing, and it might be useful. And I know Congressman Boyle and others may be coming to Ireland at some point, that if a congressional delegation comes that, uses its power and its weight, to raise this with the British government, both in London and in Belfast and in Dublin, of course. But also it would be important because the Senate, through Senator Menendez and others, and the good work of yourselves, both houses have spoken out. It's probably time, and I said in my opening remarks, that we need some kind of summit which brings both the governments and all the parties, but victims' representatives and experts together. They kind of come back on the message in terms of the Stormont House agreement, what was agreed. Ultimately, this was the compromise. Stormont House was a compromise that families made as well, in the interest of trying to move society forward, but in the interest of truth and justice also. So it would be important to redouble the efforts with the Biden administration to kind of put a focus on this, and to encourage, in a diplomatic way, to get the British back from the brink and the cliff edge and get them refocused on what is purposely required here. Thank you.
Anybody else before I yield back? Let me just say, I want to thank Chairman Smith for helping to put this hearing together. I think this is timely. It is important. It is something that a lot of us of both parties feel strongly about. And again, I always, to me, this is an important point for the British government to understand. There are lots of things in Congress, in the United States Congress, that divide us, that have us on different sides of issues. But this is not one of them. And I think there is unity here, in our belief that there ought to be accountability and justice, and that there ought not to be this blanket amnesty or let's forget about the past approach. And I think, this hearing and some of the suggestions that have been made here in the fall, we will do with the Biden administration, you can be assured that we will work to implement your recommendations here. And
Co-Chair McGovern, could I just cut
Yes.
across you there? Sorry.
Sure.
It's very, very important that that both yourself and Co-Chair Smith and other congressmen and others that are on the call tonight realize that this is not a fait accompli yet. There's no legislation passed. This is all to play for. But what we need is leverage, and I can't think of a more vital lever than the Biden administration, particularly in the aftermath of Brexit, and with the fact that the British government are seeking trade deals and all sorts of things. With that Tory majority in the House of Commons, the political parties are almost redundant in terms of making a case and to stop these proposals going through. But others of influence, and yourselves included, could yet be the difference here. So I would encourage you just to not give up. We're not giving up. We're keeping fighting, because these are abhorrent. They are an absolute travesty and a complete injustice.
Thank you. Thank you. Well, we're not going to give up, and we will work together to go to reach out to the Biden administration. Did somebody else say? I didn't.
Congresswoman.
Yes. Okay. Well, that's Sheila Jackson Lee. So I'm going to yield back to Chairman Smith, and I thank you all very much for your testimony, your commitment to human rights, and for your courage too. I appreciate that very much. All the best.
Thank you very much, Co-Chair McGovern. I'd like to now yield to Sheila Jackson Lee. I understood she had some connection problems earlier in the hearing, but we have her now. So the floor is yours.
Well, let me thank both of the co-chairs, Chairman McGovern and Chairman Smith. I was here and my fingers were nimble, but not nimble enough, Chairman Smith. So got to give me a little bit more time to get to the mute button to make sure that I get on. It has been a very interesting and important hearing. And to all of those who are making presentations, just a little slight history about me. I'm not going to ask too many questions, but in actuality, as I looked at the Good Friday Agreement of 1998, I've been in the United States Congress since 1995 and had the privilege of traveling with Chairman Gilman in the six-party talks, and literally travel from one location to the next, speaking to different groups about the issues. And so this is very near and dear to my heart. I am certainly stunned regarding the Troubles moment when loss of life was up to 3,500 or more, to even hear that there is a discussion of legislation to ban all prosecutions, impede investigation, preclude victims' civil liberties and civil claims in connection with the Troubles and others. And I do believe that we're better if we address the question of human rights, and that everyone should have the right to have their issues addressed. Not their issues, but their pain, their losses addressed. And if we would even think to pass legislation like this, that would not be the case. So I'm just going to go directly to Mark Thompson, the Chief Executive for Relatives for Justice, and Geraldine Finucane, if I have it correctly, and you will correct me, the widow of the murdered human rights lawyer. Just tell me how many people will be deprived of justice, and the pain that will continue, and the undermining of any peace agreements that already exist that will come about if this actually becomes law. Would you start, Mr. Thompson, please?
Well, approximately 1,700 families have never had any accountability whatsoever. And while others have had a measure of accountability, it hasn't been in regard to the full truth about the circumstances. The courts were very circumspect on what information was released. So it affects wide-rangingly. And we've moved on 24 years from the peace agreement, but probably 3 decades from the actual ceasefires. So as Alan correctly said earlier, we're looking at grandchildren and great-grandchildren who weren't even born and didn't know their kin when they were killed, but have lived their lives framed through the prism of injustice, and the kind of resonation of all of that in terms of has framed how they have become adults. I just oftentimes think of Pat's case, and I think of Michael and John, 2 of Pat's sons, and Catherine, his daughter, and how Catherine has went on in her life to support people with trauma and mental health issues, some of it arising, or most of it arising, from the conflict, and how John and Michael, as advocates and lawyers in their father's footsteps, have picked up his mantle and helped so many other families. And their children now, and Geraldine's grandchildren, even in terms of my own family, one of my own sons is a lawyer, and he's interested about what happened to his uncle. And Alan talks about Zoe being 30, and when Sharon was killed, she was 29. And so we are now moving into second and third generations that won't give up and want the truth. So the cost of not doing this to society more broadly in terms of reconciliation and coming to terms of the past, but also our confidence in the political institutions that we invest in and hold so dear that stem from the Good Friday Agreement are all threatened by the failure to address this. Because how can you say to someone that looks at such an egregious crime and says, well, here's a government going to just draw a line under it and excise it as if it never happened and bring no accountability? Well, how can they have faith in the rule of law if this can happen? So it has far-reaching consequences in terms of every aspect and institution within our society that flows from the Good Friday Agreement.
Congresswoman Jackson Lee, do you have additional questions?
I asked the question of the widow of the lawyer to answer the same question, and then I will conclude. Let me, as I do so, thank both of you and indicate my commitment to working with both Co-Chairman Smith, Co-Chairman McGovern on this issue. I have a special interest in it from many years back, but if I would get the same answer from her. Thank you.
I'm not so good on figures as Mark is.
Thank you very much to the chair and to the ranking.
I'll go ahead anyway. I'm not good with figures and things. All I know from my own experience is when I started off and I thought this was asking questions about the murder of one person. Over the years, I suddenly realized, firstly, that it was more of an umbrella group, and then that it was a strategy that appeared to be inflicted on everybody, no matter who you were. And people used to come up to me and say, please continue doing what you're doing. We aren't able to do it, but if you continue on and find out the truth, it will help us, you know, because we know that what happened to your husband, a similar type of thing happened to our loved one. Now that was in the early days. Some of those people now have been empowered, and I have met them. They have joined groups and they have started searching for stuff themselves. So it's important. It's one of the reasons why I haven't been able to give up, because it means so much to so many people who have no other voice.
Congresswoman Jackson Lee, any further questions of our panel?
Thank you very much. Thank you.
She finished. All right. Thank you, Sheila. If you have anything further.
No further questions. Thank you.
Okay, thank you. Appreciate your input. Again, I want to thank all of our distinguished witnesses. If there's anything finally you would like to say that perhaps we missed, didn't ask the right question, or thought of an additional answer to a question posed earlier, just for the record, we're putting together a resolution, and the input, we wanted to wait till this hearing was over to get full input from, again, our witnesses. So thank you for that. I think the idea of a summit is an outstanding one. I think the administration can be encouraged to embrace that, and I think we play a very, very meaningful role, because as was mentioned just a moment ago by Alan, this is not a done deal, and if this can be checkmated before it goes any further, we were unable to stop it. I did hearings on it as well when the public inquiries legislation was being considered. I couldn't believe that you give veto power to the very people that are being investigated under some rubric of national security, where you could put everything under the national security title and say everything is off limits. There's ways to make sure you get an unfettered access without in any way violating national security. Again, it was a ruse. and one of our witnesses talked about rogue state. This initiative is something you would find in a rogue state, not the UK. So my hope is that they're listening. I hope they're listening to you, because these all of our witnesses have been outstanding. You've hit it out of the park, as we say over here, home run, because you brought out so many important aspects to this. But if there's anything we missed, I'd like to yield to you for any final comment. If not, oh yeah, please.
Co-Chair Smith, can I just say, now that the pandemic is in remission and we're seem to be coming out of that very dark period of a couple of years, if you are you and Co-Chair McGovern or any other congressman are in Northern Ireland, we'd love to invite you to the Wave Trauma Centre on your next visit to come up and to meet with some of the families of those that have lost loved ones. And when Co-Chair McGovern was talking about the disappeared that he met some years ago, we also have our own disappeared families here, albeit perhaps not as many as in some countries, but there are still families out there that are still looking for the remains of their loved ones. So we would love to come up to Wave and to meet with some of the families from right across the divide, to hear their stories and where they're coming from. But can I just say, certainly on behalf of me and my other colleagues, just thank you for the time you've taken tonight to listen to the stories, to other colleagues, Geraldine, John, Louise and Mark, and just a big thank you for the time that you've taken to listen to us. And remember, the closing word, this is not over. This is not in legislation yet, and it's all to play for. And I know that the American government can have a big role to play here on changing the mind of the British government. They say they're in listening mode, and if they're in listening mode, then they need to hear it loud and clear that this blanket amnesty is just not acceptable.
Right, thank you very much. Thanks for the invite. We hope to take you up on that. I understand that Professor Mallender would like to comment. Louise?
Hi, I'm sorry, I wasn't indicating I wanted to come in, but I guess I would say thank you very much to everybody for all your interventions tonight. I think it's really heartening to hear the level of commitment that you have, and I look forward to you coming to Belfast.
Anyone else before we conclude?
Chair, John Boucher, can I just come in very briefly?
Chief Constable.
So it's only a final reflection. The command paper obviously came out last summer, and there's been a number of different strategic positions since I've been involved in Legacy in 2016. The undertaking was that there would be draft legislation in the autumn. It didn't arrive. Then that there'd be draft legislation before Christmas. It didn't arrive. Then that there would be draft legislation in early January, and it hasn't arrived. And the Secretary of State, Brandon Lewis, was in America, in Washington last week. I am a realist, but I am also an optimist. I do genuinely believe that there is a changing position of the government. I certainly hope there is. And I do think that recently they have been engaging in a more meaningful way with stakeholders, particularly in my view, they need to do so with victims groups. That for me is the particular cohort of people that should have the voice in this. So for you to carry on lobbying, and I very much support Alan Mcbride's comments, to really push forward now with the messaging, I think is actually especially important, because I do think we're at a tipping point where we might see some shift in strategic approach, but any additional weight behind the door, I think, will be gratefully received.
Thank you, Chief Constable. I'd like to thank all of you for your testimony, your admonishments to the government, your encouragement to all of us to stand up. You know, I often say friends don't let friends commit human rights abuses, or friends don't let friends commit cover-up either. And your testimonies have been outstanding. This hearing is adjourned, and I thank you again. Oh, before I go, there's a couple of, I need to ask unanimous consent that a statement by Daniel J. O'Connell, the National President of the Ancient Order of Hibernians, be included in the record. Brian Dooley, Human Rights First, Margaret Irwin, Coordinator of Justice for the Forgotten and Amnesty International, and additional information being provided by Mark Thompson and Chief Constable John Babshir. Thank you very much. The hearing is adjourned.